Welcome to the Successfully Retired podcast with Hamilton Brandenburg.
Today we've got an exciting guest. I'm happy to talk to Jeff Bowers. Jeff is an attorney that I've known for several years now. Has helped a lot of my clients with estate planning questions and needs that he has. Quick introduction about Jeff. So Jeff actually got his undergraduate from Emory and then his law degree from Georgia State. And Jeff, if I read your bio correctly, you're a couple years up from 30 years in the bar in Georgia of practicing law. That is, A, that's phenomenal that you've got that much experience, but B, I also thought that you were like a lot younger. You look a lot younger. You're young to practice for 30 years.
1997 is when
That's
I passed.
that's awesome, man. Well, congratulations. Well, tell our listeners who haven't met you perhaps a little bit about you, your background and your firm, and kind of what do you guys do at the Bowers Law Firm?
Sure. So, for many years, beginning the practice of law, I did primarily real estate.
Okay.
We did a lot of, started off a lot of residential real estate, and then I worked for a couple of larger firms, ran some offices for them, and then
Sure.
in 2006, I started my own practice, and that was right as the real estate crash was happening. So it was within a few months of opening our office that happened. So don't ask me for business advice. That was
That's
poor
tough.
But
what a tough time to be working in residential and real estate.
Yeah, and so we had I have 7 children. Believe it or not, I know you probably have me beat, but
I'm only at 4, so it'll take me a while to catch up to you.
Okay. So I had young children, babies at home, and it was sink or swim. And so one of the things that we did was, we expanded into different areas. So learned more, and the areas that we practice in are estate law and business law. And those really dovetail very much with real estate. All 3 of those arenas, interact with each other.
Oh, and definitely.
And so, already had some experience in those arenas just from practicing real estate law, but became more educated and familiar with, how to help people in those 2 different areas. And so,
I think those 2 tie together really well. You think about, a lot of folks think about their wealth as being their investments their liquid investments that they put money into the stock or my 401k or whatever. But I mean, your even if it's just your primary residence, even if you're not a landlord, your home and the real estate that you own ends up being probably the biggest, or if not the biggest, one of the biggest parts of a family's net worth, especially.
And almost necessary in my mind, Hamilton, that if you're having an attorney help you, that they have, knowledge and experience in those areas. And then, the business law ties in. Not everybody has their own business, but a lot of people do. And for those folks, how do I transition, owning and running this business to passing it on to the next generation?
That's a really good tie into one of the big questions I wanted to run past you on our call today, and I think it'd be super valuable to our listeners. Something that I didn't do early in my practice that is now like mandatory when I'm meeting and I'm onboarding new families to work with is I want to review their estate documents. And I'm not playing lawyer, but I want to make sure that they have an estate plan and that they can at least articulate what their wishes are to me. And I can say, hey, look, you might need to get this re-reviewed because what you had done no longer seems to match what you're articulating. You said you wanted the money to go to Jim, it was going to Sue, or whatever the case may be. But one thing that I have noticed is when we do this process, we get a big binder brought in, right? And people are just kind of like overwhelmed, and they're like, here's the binder, and why don't you just walk us through like what's inside that binder? What are your estate documents, and what do they really do actually?
And I think you touched on something that I'm pretty passionate about, and that is that I think that you need to have any service provider like an estate attorney that you have or a financial planner. I think they need to be at heart somebody who enjoys teaching, and so or maybe at the minimum making sure that their client understands what are we doing here. based on my goals, what is important to me and what are the mechanisms,
Yep.
and break it down in the simplest terms as far as what we're doing to accomplish those goals. And so I run across people very often who come to my office, and it seems like, not to disparage other attorneys, but that there are other attorneys out there who are almost just order takers. You want a trust? Okay, I'll do a trust for you. You want X? I'll do X. Instead of asking questions, who are you? What do you have? What's going on in your family life? What do you want to accomplish? What state are you in? All these different, here's just an example, a quick example, is that we get a lot of people who come from states where it makes sense to use a trust as a will substitute. In Georgia, where I practice, that's not the case typically. And so, rather than sell you a trust, which I could charge more money for, once I know more about the situation, maybe that's not the best avenue for you. Maybe a will in Georgia is going to be the best route. But so having said all that, I just feel like, my job is to know who are you and how can we serve you best with what's available out there.
It's funny you mentioned that. So the podcast episode I released today, on the day that you and I are recording this, was just like, hey, general estate planning mistakes that I see pretty commonly in my practice, and nothing too overly complex. But a big one was, I can't tell you how many trusts we get that are unfunded because the funders of the trust, the creators of the trust, the grantors, didn't really realize they were supposed to do that. And to your point, not to be disparaging of anyone in the legal profession, because it's a lot, it's overwhelming, but you just kind of wonder, like, somebody paid thousands of dollars to get all this done, and then they either didn't know, or there was just no process in place to make sure that the funding of it happened. And it's the simple stuff a lot of times.
Yeah, not enough education, I don't think, because you want to trust, here's your trust, and then and to somebody who doesn't do this every day, they that's a very important step. Now we got to put the stuff in the trust. How do we do that? And it's different depending on what the asset is.
Yeah,
and so,
big time.
So the basic documents, in Georgia, of course, you can have a trust, and there are reasons to do that.
Sure.
But what most people need is what we call a simple will, and that's that instrument is basically where you say, hey, this is who I want to be in charge of my estate when I'm gone, and some suitable backups if you have backups to that primary person. And this is what I want to happen with my assets. Okay. And so that is super important, because if you don't do a will in Georgia, then you have an intestate estate is what they call it. And what that means is that your assets are going to go to your legal heirs. And that's defined by law. And so it may not be who you want your stuff to go to. And the person that you would have preferred to have been in charge of, making sure your assets were gathered and your debts were paid and everything was distributed the way you want it, it may not be that person who steps up and gets appointed as the administrator. So
is that process of dividing your assets among your legal heirs, or however you define that, does that process take longer than if you had a will and it had been laid out? Like, what does that actually look like if you do die intestate? Even just saying intestate sounds horrible. I don't want to die that
generally
way.
Yes. I mean, there could be circumstances that make probating a will take longer. But generally, let's just assume that everybody is on board with a petition to probate a will, or on board with a petition to have an administrator appointed. At minimum, you're going to have to publish notice once a week for 4 weeks after you file your petition on the administration. And so that means, whereas it might be, depending on the county and the court, 5-10 days, before the petition's wrapped up.
Sure.
Now it's a minimum of 4 weeks before the judge will even look at the petition.
Wow. So you're looking at minimum 4 weeks before you can even start moving forward, compared to if you'd had a will, you could have got the ball moving forward. And not to mention the added benefit of, well, in the will, you actually get to decide, and beforehand, who gets what. I like to tell clients, like, hey, your estate documents are not just about like having some $10 million net worth and some crazy, it's just like who gets what, who does what. Decide now while you can. And it's a lot easier. And
there's a bunch of reasons, but that's, what you just said is the primary one, or at least the first one to consider is, you want to be in charge of who handles your estate and where your assets go. And let me add to that, though, an important addition to that is if you have minor age children, what you're also doing in that will is you're stating who your preference is to be the physical guardian for those children, and also who's going to be in charge of those assets for those minor children if they're receiving anything. So, if something happened to mom and dad, you're selecting who the trustee will be that will manage those assets for those minor age children. And that's huge. I mean,
yes.
Depending on family dynamics or whatever, if you don't do that, somebody could step up to try to ask the court for that role that maybe you wouldn't have preferred. And so so I just wanted to add that. And one other thing is, you mentioned your clients coming to you and handing you the book, and they're like, something's here.
Yeah.
I mean, I'm more than happy. We have this call occasionally where people say, "Hey, I don't know if I need to update my will or not. I don't know what I have." I say, "Send it to me. We'll look at it, and then we'll basically have a little quick meeting and tell you this is what you have currently. Do we need to change anything?" And so
you and I have actually done that for a couple of clients before.
Okay.
Where and that's been huge. Where I remember a client, now I can't say his name obviously, but he had a really big push from a big firm that, hey, you need to redo this and you need to do this irrevocable trust, which we won't even get into on this call. But it wasn't something the client was comfortable with, and he ended up reaching out to you, and you were like, hey, actually, what you have is really what you need. So yeah, sometimes just getting a second opinion can save you a lot of money a lot of times, and a lot of hassle and headache as well, for sure.
Yep.
Absolutely. So your will is your basic one. What's your next kind of basic estate document that you have, and what is it?
The two others that we recommend to most folks is, a financial power of attorney, and Georgia has a statutory form, and then the advanced healthcare directive.
Okay.
And so a financial power of attorney, I know, but in a nutshell, what that is you're appointing somebody who can pretty much be you while you're still alive. So as an example, my wife and I have given each other that authority. So even though I'm on most things with her and vice versa, if I'm unconscious in the hospital, she can be me. She can, write contracts in my name. She can move money around. She can do whatever. And so a valuable tool, you got to have a high degree of comfort with who you're giving that authority to.
Oh yeah, it's huge.
Huge, but very useful tool. And also when you get older, we have clients who they get to the stage where they want to start delegating, tasks to other folks. And so they will give that power of attorney to a trusted child or relative or whoever. And then that person starts handling the affairs of the older person as just to relieve them from that burden. And so that's a useful scenario.
Could you have scenarios, and I think I know the answer to this, but I think our listeners will find this interesting. Two questions about financial powers of attorney. One, let's say you wanted to give power of attorney. Say your spouse has already concluded her retirement. You want to give power of attorney to your son to start managing some stuff, but you don't want him to be involved in, let's say, real estate transactions, or you don't want him to be involved in making decisions around your pension or your stock account. When you talk about the Georgia form that they use, how much customization can go into naming a power of attorney, or are you just like, hey, I'm signing my life away completely?
Yeah, and that's a great question, Brian. So there's a list of specific areas where you can delegate or give, that authority, and you can choose them all, if you want to, but it's you can pick, specific areas that you want that attorney, in fact, to have authority for you. You can also, make it limited to your disability. If you just say, hey, I can take care of myself, but if for some reason I can't act for myself, then my attorney, in fact, can step in.
So talked about financial power of attorney, talked about will. The next thing you brought up was advanced healthcare directive. Tell us, what is an advanced healthcare directive? What's inside of it? How does it work?
Yep. So first of all, it's healthcare power of attorney. So just like on the financial, you're saying, hey, this person can be me, or do things that I would do for myself normally. The advanced healthcare directive is nominating someone and some backups to make your healthcare decisions for you if you can't or won't make them yourself. And so, you know, typically most Georgia medical, facilities and practitioners are going to listen to the closest family relationship, usually a spouse, but they're going to, typically they're going to honor, the decisions of the closest family member. But what this does is it codifies who you say, this is my agent. This is my person that I've designated to do this for me. And so when necessary, it's a very valuable tool because you can show the hospital or the doctor, hey, they can't make this decision, because of capacity or whatever, or won't make the decision. I have the legal authority to do that.
And so, I would imagine this is a really important place that if you did have very specific wishes for your end of life treatment or just your healthcare treatment in general, that you would have an opportunity to lay out what those wishes were. If for example, if I'm, I don't want to be kept alive for, too terribly long, or I want them to try to extend my life, or, I really want this or that kind of treatment. Like, you would have the opportunity to put that in writing so that way your wishes were at least known by your agents, right? Is that kind of how you would describe that, or somehow differently?
Absolutely. And uh, all of your listeners may not agree with me on this, but I feel pretty strongly that, we have to be in charge of our own health care. It's not just taking orders from the doctor.
Definitely.
It's our health and our bodies. And so, I want, while I can, I want to evaluate the information that's provided to me by the healthcare provider. But at the end of the day, it's my decision.
Yeah.
And so in keeping with that, that's why I want a healthcare agent, because I want somebody who knows me and cares for me, who's going to be my advocate in the healthcare arena. Because, a lot of great people who are healthcare providers, fantastic folks, but, they're not your family either. And they're not, nobody has your best interest at heart more than you or your loved ones. And so
we could do a whole episode on that too. I mean, I have immediate family who are healthcare providers and who are first responders, and I've even had experiences over the past year where my son was hospitalized for a while, and and this is not to be disparaging of the medical profession at all, but there are times where we've had to really be advocates for the person who's getting treatment, and
100%. I mean, we've had the same. We've had experiences with family where, I mean, again, we want to think the best of everyone and think the best of their motives. And there are great people out there, but people are people, and so you have to be the biggest advocate for your own health care and for your families. I mean, and if you're not, then there is a potential for things to happen that are not optimal. And so,
even just mistakes and human error. So anything else you want to add about Advanced Healthcare Directive? Because I do want to ask a couple other questions about a few other things, but I don't want to skip over this part. I think it's really important.
Yeah, the living will is another portion or part. Well, there's two other parts. So there's a living will, which I'll come back to in a second, and then there's also a guardianship nomination. And so what you can say in the directive is, hey, if I'm ever so bad off that I need to have a legal guardian appointed for me, this is who my preference is. And so that's just where you get to exercise another element of control over your life and your decisions. So you get to choose, hey, if I need somebody to take care of me and be legally responsible for me, this is who I want it. If you want to, you don't have to do it, but you can state what your treatment preference would be if you're in a terminal condition or you're permanently unconscious. And the funny thing about that is, I didn't really understand the benefit of the living will until I had hundreds of people pass through my office. And so what I learned was that, particularly for adults who had to make end of life decisions for an elderly parent, very difficult decision to make. And so when mom or dad in writing had expressed what their wishes were, it alleviated the burden for those adult children. And where it was not present, where there was doubt, it made that difficult decision even more difficult. And so And so that really struck home with me as one of the benefits of doing the living will is that you're taking the burden of making that decision off your family. You're saying, hey guys, you don't have to worry about it. You don't have to fight about it. This is what I want you to do. And so I'm a big fan of the living will for that reason.
I've never thought about that. And now I'm thinking, okay, I know that on my advanced healthcare directive that my living will is blank. And now my kids are still really young. But I'm like, I think I'm going to go through and just make this easy for them. Because like you think about situations like, especially occasionally, I doubt, I don't know if you see this often or not, but occasionally people might name two people to concurrently serve as the healthcare representative or the healthcare power of attorney. And sometimes maybe that makes sense. It also, like, two decision makers can sometimes make things really complicated. But if you were vague with your wishes and grandma's on knocking on death's door and like one person really says, no, we have to try to extend her life. And the other person said, well, once she talked to me that she never wanted to be in this situation. Not only is like, an elderly parent's in a really bad limbo position, but you might just be creating a rift that's going to divide your family for the next 20 years and ruin Thanksgiving and Halloween and everything else because, her wishes were not clearly articulated. So everybody thinks they're being an advocate for her, but they have different points of view. And now the family's torn apart because
100%.
That was left blank. I've never thought of that before, but that's going to be something that starts to be on my review process a little more detailed, I think.
Yeah. There was a huge case involving Terry Schiavo is the name. And so, it was, it's been years now, but the family, tore the family apart. They, as far as one side wanted, thought she would have wanted one thing and another side.
I remember that.
Yeah. So yeah, that's when we go over the directive. Those are the two big ones that I mentioned is, hey, look, you're taking the burden of making this decision off your family and you're eliminating any potential controversy. And so those are the primary benefits for sure.
That's huge. All right. So we talked about financial power of attorney, your will. We talked about your advanced healthcare directive, healthcare power of attorney, and living will. You said something that I really want to make sure we talk about before we end our call today. And there's a couple of questions I have for you, time provided. But you talked about, hey, you kind of prefer not to just overly disseminate your legal documents and your POAs, not overly just like hand these out to everybody willy-nilly. And I think there's a lot of great reasons for that. But tell our listeners why. Like, who should they be giving their legal documents, like their will and their trust and stuff, a copy of that to? Who should they not? And like, why would you not want to be just handing that out to everybody?
And it's a great question. And it's a good thing to think about proactively is, first of all, all of these important estate documents, wherever you keep them for safekeeping, anybody that you've given a job to in those documents, whether it's executor, attorney in fact, healthcare agent, they need to know where you keep them and how to get their hands on them if they need to.
Okay.
And so that's the first thing. And it's not a bad idea to have some of these you're going to want the original, the will. Preferentially, we're going to have the original. It's not the end of the world if you don't, but we want the original. It's a good idea to keep copies, or at least another set of copies somewhere else. And again, make sure that the people you've given a job to know where that other copy is. And then it's a comfort level thing. If you, the reason why you don't want to have copies floating around to anybody and everybody is that you might change your mind. And change a document, and you could create confusion, once the document needs to be used about which one's valid and which one's not, and circumstances can change, and so you may say maybe you gave son A a job in one of your documents, and you've given him that document, and then that relationship changes, and detrimentally, and then now you've got potentially a legal document floating around out there that it could be misused, particularly if you've changed things. And so we just don't want to, the possibility of change is why you want to keep copies as few as necessary.
Where should people store their legal documents? Should they put this in the safe or should they not? Or should they?
And I'm open to, again, improving our advice on this. I mean, you want to physically protect the documents. I mean, so, so I'm not going to, so a safe is not a bad idea as long as you're comfortable giving the access information to whoever needs to get to those documents.
Yeah.
I will tell you as a quick aside, very often people would, as a matter of practice, would put it in their safety deposit box. Well, in Georgia, if you're not on the account with the account holder, you're not allowed to get to the safety deposit box, even if you're the executor in the will. So what we have had to do sometimes is, get a court order for somebody to go examine the contents of the safety deposit box. So that's just a quick little aside. But so physically protecting the documents, I think, is very important, as long as there is access by the people who need access. That's it, really. I mean,
that's a great way to put it. As long as there's access by the people who need to have access to it, don't create a surprise by hiding it in the safety deposit box and leaving breadcrumbs for somebody to find later, and then they're like, oh, I gotta get a court order for this. All right, so couple more questions if you don't mind. This one is one I've thought about. So is it, in today's day and age of everybody can be hacked easily, stuff can be stolen if it's online, is it a best practice to have a kind of like a cheat sheet of here's where the bodies are buried? And this doesn't refer as much to your legal documents, but more like saying, let me put on a piece of paper, here is who my insurance is with, here's the name of my financial advisor, here's the name of my CPA, this is the bank that I bank with, so call them if I pass away. Kind of like a, in the event of, I know obviously you wouldn't want to put account numbers. You wouldn't want to be like, here, I have Bank of America, here's my account number and my social security. You don't want to do that. But what's the best way to leave that breadcrumb trail behind for people who might have to go and clean up afterwards when you pass away, and find where all your accounts are to start adding up what your estate is?
That's a great point, Hamilton. And this is something we talk about with every client also, is that it can be very valuable to those that you leave behind for them to know, what do you own? What do you owe? How to access these things, passwords, I mean, so it used to be that you just wait for the mail to come in, and then you'd know, what people owned and who they owed money to. But it's huge. You get, you have the balance of, you want to protect that information, but also it needs to be provided to your people that you've given the responsibility of wrapping up your affairs. I mean, if they don't, if you don't have if you don't get mail on an account, and they don't know, even though you have it, or how to access it, well, or maybe they don't know how to get on your computer and look at your email. I mean,
exactly.
It's whether you feel comfortable having an electronic database of this information, and you feel like it's protected, or if you feel more comfortable with a hard copy, that you put where it's only accessible by the people you've given these jobs to. You have to be able to provide that information. I mean, there's, if I had, my wife and I are executors for each other, but our backup executors, they don't even know who we bank with. They don't know any of that. And so, they would have a very tough job if we didn't have a way for them to access that information.
Or I think on that note, I think when I send out this episode, if you're listening to this, I'm also going to put in the show notes, we have a in the event of kind of format that we have put together for our clients, where they can just list out, and it makes sure to put on there like, hey, don't put your social security number, don't put your account number, your date of birth, but a place for everyone to list out who's the mortgage with, who are your credit card companies, who do you bank with, who's your life insurance with, so that way they can start to track that down. So we will make that available in the show notes for people who want to download a copy and start just creating their own little cheat sheet for how to find everything if they were to need that for themselves. Couple last questions. How often or when do you think somebody should review or change their estate documents?
Life changes for sure. And so marriage, unfortunately divorce, having children, that's a time to, answer those questions of, well, who would get the kids if both parents are gone, and who would receive our assets. When the kids become adults, that's maybe because very often, people will do an estate package when the kids are young,
Yeah.
And so they're selecting people to do certain jobs. And then the kid now, the kids are in their 30s or 40s, and the parents would maybe want the kids to do those jobs. And we don't need guardians and trustees anymore. And maybe we have more assets, and we have more specific things we want to do with those assets. So definitely life change events. And then, maybe every, decade or so, or revisit, because, life circumstances change, your asset picture changes, relationships change. I mean, I think life changing events, and then every decade or so would probably be a good rule of thumb.
That's a great rule of thumb. And one thing I think we're going to start doing in our practice is maybe biannually just sending a snapshot to our clients of what their, as far as they've articulated it to us, what their executed estate would look like if it happened today. You die, it gets split up and sent to the kids or with the church or whatever. This is how much money they get if it happens today, based on our best understanding of you, of what you've told us, what you've shared with us, and use that as a trigger. Like, is this something you're still comfortable with? Because if not, maybe it's a good time to revisit that. So I don't know what the cadence will do, but I think maybe every 2 or 3 years, just a quarterly summary or something for clients.
I think that's fantastic, because, we're everyone, I mean, myself included, we get busy with life.
Same.
And 10 years can go by, and you're still just trying to keep up with the pace of life, and you forget, gosh, what did we do? Who is the things that we have, or who is doing these jobs for us? Absolutely.
Are there things that we should be listening for that indicate now's a good time to make sure they get a referral to an estate planning attorney to have a further conversation?
Yes. Well, a couple of things jump to mind immediately. And one is, if they've had their documents done in a different state. I used to tell people years ago that, hey, look, the basic requirements for a will in Georgia are not, complicated. Is it in writing? Was it signed by the maker of the will? Does it have witnesses? But there are, laws in different states where it can impact how your estate is administered. Thank you.
Okay.
If you're going to South Carolina, I'd say, hey, you better get your estate documents reviewed by a South Carolina attorney, where their documents prepared in another state. That'd be a trigger for me.
Okay.
The next thing is, did an attorney prepare them? And is that attorney's primary practice estate law? And the reason for that is, we have had many wills come through our office that were done by the person themselves, and they just found a form online, or it was done by an attorney friend who doesn't do estate law, and they have been deficient at the best in some of the things that we would like to see in a will, and at worst, they were not even sufficient to offer for probate.
Wow.
So, yeah. In fact, we just helped a good friend of mine from high school, who his dad's a very, very smart guy, but he did his own will at the end of his life, and it was missing some things that will now cause, it's not the end of the world, but will cause extra work and burden for his son, who's his executor. Whereas if they'd had somebody, that does this on a regular basis, it wouldn't have been an issue. So,
wow.
Yeah,
that's huge. Those are great. Well, we'll keep those in mind going forward. Any other parting thoughts?
When you're interviewing estate attorneys, just like financial planners, find somebody who's a good fit for you, who's willing to answer questions and spend time with you, and make sure they understand your situation. And I want to say, for you, I think it's just what a great service you're giving to your clients to even talk about this, because it's something that you can do to add value to their lives. You're helping them put together their asset picture for the rest of their lives. And this piece is, well, what's going to happen to it all? And so,
sure.
I think it's fantastic service to give to the folks that you work with. And so, definitely commend you on that.
Well, thank you. Like I tell my clients, we're all going to conclude our own retirement someday, so we might as well go ahead and decide what that's going to look like now. That's awesome. Well, Jeff, this has been a great talk. Thanks again. Definitely want to have you back on sometime.
All right. Thanks, Anthony.
All right, thanks.
This show reflects the personal opinions and viewpoints of the host and Brandenburg Financial Services. Opinions and viewpoints are subject to change at any time without notice. No representation is made as to the accuracy, completeness, or relevance of the information presented. The information discussed is general in nature and does not constitute investment, tax, or legal advice. Consult with your tax, legal, and financial professionals about your specific situation. Past performance does not indicate future returns, and any indices mentioned are for reference and cannot be invested in directly. Brandenburg Financial Services is a DBA of CS Planning, an SEC registered investment advisor.